I'm not going to hit the gavel again, but, so I'd like to call the Tuesday, May 16th, 2023 Planning Board meeting back into session. We do have a quorum, and we are moving straight to item 5, where we left off. Discussion of Marvin Development Ordinance MDO project. Hunter.
Yep, so I've provided, this is our first couple articles that has been provided by Rick here. They are provided in your binders. I'm gonna let Rick kind of go through the articles. I think the step in the process is introducing these tonight. You know, you guys can ask questions, learn it, and then we'll kind of come back and at the next meeting and summarize, go over, make sure there weren't any issues with the articles provided, and then we'll kind of do the next thing with the next couple articles. So turn it over to Rick, and we'll go through these first 5. So they should be in your binders. It's Articles 1, 3, 4, 5, and 6. There should be tabs in the binders so you guys can follow along. But Rick, I'll turn it over to you.
Thank you, Hunter, Madam Chair, members of the board, and distinguished council member. As Hunter stated, we'll be playing kind of leapfrog. As a quick reminder, we'll do an introduction like tonight. Then at the next meeting, we'll have time for review of those, any comments, questions, feedback, edits, deep dive as deep as you want to go. But that gives you that period of time to actually read through everything after it's been introduced. Then at that next meeting, after we finish reviewing the ones you're going to see coming to you tonight, then we'll introduce another little batch. So we'll be able to constantly review and also introduce new material through the bulk of the time here in your hands. The last few meetings will be reserved for that context that you will then have, which is sort of the whole thing in perspective. You know, once we've been through and individually with each article at later date, you will then sort of get it. The aha moment will come together. As I said in my brief introduction, general introduction to you last month, we will build this in silos, because while narrative style ordinance writing sounds like a good idea, it actually doesn't work particularly well from an administrative standpoint. You get inconsistencies, or you get gaps, you leave things out. So if I wrote a story about apartments, or I wrote a story about farms, or wrote a story about office buildings or shopping centers and what have you, you're going to end up with a lot more material if you repeat the whole discussion about landscaping or about whatever the topic, parking or whatever the topic might be. So we compartmentalize or silo this so all the parking material is together with only a few exceptions, where all the landscape material is together with very limited or few exceptions, that kind of thing. And you'll see as this goes along. And it makes for more consistency, greater consistency in administration. So in the reading guide that we distributed, remember we broke it into three groups. The boring, which is officially named administrative and procedural, is the main subject of these first couple of meetings. Articles 1, 3, 4, 5, and 6 that were introduced, or that are going to be introduced tonight, are the first half of the boring stuff, and then next meeting, we'll introduce the second half of the boring stuff, and hopefully start getting that out of the way and behind us. So what is Article 1? Article 1 is really creating the ordinance. It is ordaining that there will be standards. Here are these standards, and there's a number of elements. So I want to walk you through it. And at a point down the road, you'll get a table of contents for each individual article too. Okay, as I get more of this in shape and in order, you'll see a table of contents for each individual article. So it'll have a lot of detail in that table. So let's sort of walk through it. The first thing that I do, and this is kind of unique, most ordinances, the signatures are at the end. I do them at the beginning of this because it's so long, so beefy, and I sort of create the enactment, and that's also where we repeal the old thing. So you will see yellow as those are flags. like this date that's filled in here. There's nothing official about that date, other than that's the way our timeline sort of played out. So that right now is nothing more than a goal right now. But anything yellow will be something we come back to. So I automatically know certain things we've got to circle back on, getting the information about your current ordinance and what have you. So that's the first thing we do, is we create this thing and we repeal the old standards. Now, sort of flipping through, Article 1 is also a basket of general legislative topics. The next few pages, purpose, guiding principles, that's where we tie this into your adopted plan. As you know, in order to enact any kind of development regulation in North Carolina, it has to be in concert with a plan that is adopted by the jurisdiction. And so this is where that happens, and right up front. So it gives the plan that legislative or legal tie-in to the ordinance, okay? It doesn't mean that the plan, your town plan, is a regulatory document. It's not, but it may identify things that are important and that are in principle important to keep aware of. Let me just make up a crazy example. We know what side of town the harbor's going to be on, or the ski lifts and things are going to be on. We kind of know certain things about certain things, and that's where the principles might come in. It might be about a new intersection that we know is being talked up for improvements or changes that we want to make sure get taken into account when we're working on projects specific to properties. Doesn't mean we're going to take it away from people or anything like that. It just means that we're not going to lose sight of it. You know, right away still has to be purchased from property owners. The relationship, the jurisdiction, all pretty straightforward stuff. And the authority is what you are granted by the state at the top of page 3. And you'll notice that this 160D thing you've been hearing about for the past few years is at the beginning of the list, but there are also a number of other enabling legislative components in there that are important to at least reference when we're setting up standards for the development of a community. The next piece is important, the conflict clause, if you will. That spells things out when there's a conflict between us and ourselves within the same ordinance or within another locally adopted ordinance, or between us and the state or federal rules and standards. So that's what is spelled out here. It also speaks to something that people ask about quite often, and I'm sure is going to be an important topic here in Marvin, and that is the relationship with covenants and restrictions, those things that are tied to many neighborhoods now that establish standards that are really contractual. They're not legislative. And so this spells out where that comes into play. We don't have the authority to administer those or enforce those. Okay, we need to make that clear to folks that those standards that you've got in your neighborhood are something that you agreed to when you executed your closing documents. And that's between you and them. If they call Hunter and say, hey, our restrictions in our neighborhood say no giraffes over 8 feet tall, and I've seen a 9-foot giraffe walking through my neighborhood, and I'm going to use absurd examples sometimes so I don't use an example that's too close to home for anyone. I hope nobody's got a 9-foot giraffe, right? Okay, so, you know, he needs to be able to say that, and people need to see that very clearly, because I like giving answers when I'm talking to a citizen, when I'm doing the job like Hunter does every day, and I'm speaking to a citizen. I like to be able to show them, to tell them, not just to say it as if I'm some big authoritative figure. And that's a little teaser for Article 23 that'll come next month. And that is that I highly recommend that our staff always approach this about what the ordinance requires, or what the ordinance standard that the ordinance says, not I. It's not about me, you know, I can't approve that. It's the ordinance doesn't, or the ordinance requires something like that. So it's not about some person that they perceive as being this authoritative giant in town hall. It's tough enough doing that job already. And I've heard zoning administrators say things like, well, I'm not going to allow. And I just want to grab them by the collar right then and say, no, you don't have the authority to allow or disallow. You have the authority only to administer the ordinance. The ordinance decides those other things. Severability, page 4. Severability is weakened now by the new statutes, but not completely. Severability, it generally means that if a provision in here suddenly becomes questionable because of its constitutionality, because of a court ruling, it could be in another state, okay? And it goes, something that works its way to the U.S. Supreme Court that has implications. And what severability means is it doesn't invalidate our whole ordinance. Just that piece that may no longer be valid is cleanly severed with a nice sharp blade, just goes away. Even if we don't take the time to take it off the piece of paper, it just doesn't apply anymore, or it may apply differently now, okay? Sign neutrality, content neutrality over signage was the most recent federal level case that we really had about 8 years ago that really had far-reaching implications across municipalities throughout the country. What that means for those of you that don't know is I can't read a sign and tell you what kind of sign it is. In the old days, our ordinances had listed things like political signs, real estate signs, yard sale signs, and the U.S. Supreme Court said, no, 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 no. That's a violation of freedom of speech if you have to read the sign in order to classify or regulate the sign. That sounds great, but what about signs that say, danger, high voltage, or stop at the street corner, you know? So there are certain exceptions to that, and so what you'll see in my version, it will address what I think the intent of the Supreme Court case was without throwing the baby out with the bathwater on general public safety items. Remember the conflict clause that we talked about earlier? When that case first came down, it basically said that if your ordinance sets the most restrictive, because those conflict provisions usually talk about the more restrictive shall apply if there are two conflicting provisions, and when that content neutrality case came down from the courts, it meant that a house for sale sign and a yard sale sign, I'm going to pick on those two, suddenly there was no difference. Well, the yard sale signs in ordinances were typically 1 or 2 square feet and could be up 10 or 15 days. And real estate signs could be 3 or 4 square feet and could be up 6 months or indefinitely or whatever. After that ruling came down, technically, what were the standards for a real estate sign? 10 days and this big. Fortunately, the internet fixed that because nobody puts signs in front of their houses anymore anyway, for all practical purposes. But in your sign ordinance that you'll see coming at you that is trying to respect that, you will see some balanced standards. So we call them now temporary signs. So if I want to write 9-foot giraffe for sale, house for sale, yard sale, vote for me, I'll set you free, whatever on that sign, I get to do that. And I get these privileges, this big, this long, and you get to weigh that out. I'll show you language, and then you'll say, oh, no, we don't want any signs. And that's one of the things that some towns have done. They've just said, you know what, we're either going to open the floodgate and to heck with it, whatever they want to do, it's their town, or no, we're just not going to do anything. Or we'll set some reasonable standards and hope that the internet deals with most of the house for sale problems and everything else is moderated. So that's just an example of how severability, conflict have actually had real-world implications on you. Interpretation of the ordinance. That's getting deep. I'll let you read these things. Rules of construction. rules of construction, not building construction. This is not building a building. This is rules of construction of the ordinance. Words in the present tense include the future tense, that kind of construction, okay? These things have to be spelled out. Some ordinances leave all of that up completely in the air. Compliance. Basically, a lot of ordinances will write all kinds of wonderful standards, and I never will forget one time that had gone through about a 2-year process, and they had all these beautiful landscape and new design standards and everything else, but they failed to actually require them. They just had all this stuff. It was just all over, the beautiful drawings and graphics and all kinds of stuff, but they failed to actually say, this is required. So in the legal sense, and I'm not an attorney, okay, I do a lot of legal work with law firms, but in a legal sense, you do need to actually sometimes say what it is you need to say, the basics, the things that might sound too simple and often be overlooked. And then there's the most important page, as you will hear over the next 8 months. There's the most important page in the document. And it'll come late in the game, and it's your official zoning map. And you'll hear why as we move this process along as well. You have to actually establish it, create it. It can't be, it's not a separate thing. The zoning map hanging over there somewhere or on a website somewhere is not a separate thing. It's a page in your development ordinance. It's just a different kind of page. Okay? Interpretation of district boundaries. That's guidance for questions about, well, the map shows this over here, but I can't tell exactly where it is. Is it the property line, or is it the creek, or is it the, what is it? This gives that guidance to Hunter so that he's able to make a determination based on guidance in an ordinance and not just say, well, I think it's this. And last but not least, in Article 1, state of emergency. And this is the way these introductions will go. I'll tell you a little bit about why these things are important, how they fit into the puzzle, rather than just trying to pick it up and say once upon a time and getting to the end part. State of emergency is something that I had never seen in development ordinances, and I don't know what made me do it, but I started doing this about a dozen years or so ago, and I've expanded on it since COVID. The early version was really about things like tornadoes and tropical storms and flooding or something like that. Even national emergencies like military or warfare, terrorist attacks and what have you. Since then, I've added language that helps us deal more with things like pandemics and what have you, because if you'll think back, one of the first things that was being tossed around when the pandemic started was temporary medical facilities. Anybody remember that? Seems like a long time ago, but they were talking about setting up temporary hospitals or temporary medic facilities in parking lots at Walmarts and Targets and whatever else. And so what this is intended to do is set some parameters around that. And I'm going to give you some real world quick examples here, or at least one. One of the most common ones, and we planners, we see kind of a sharing of information on the internet among ourselves. It's called the listserv, where people will be asking questions, and there may be a disaster in an area, and the planner will be reaching out, hey, what do we do? FEMA's trying to bring in these temporary housing units because we lost, a third of our town yesterday in the storm, and our ordinance doesn't allow for that. What do I do? My recommendation to them would be just quit your job today because you're stuck. If your ordinance doesn't accommodate that, can an administrator of an ordinance decide, I'm not going to require it today? As common sense as that may sound, if you don't spell out how it happens, it can be and will be challenged by somebody, believe it or not. So this spells it out, whether it's a national, whether it's state level, or whether it's local, called by the village council. You know, the village council may declare a state of emergency for a reason, a necessary reason. The state of North Carolina may, what have you. But I'm going to give you an example of how this tool has been used. And this is going to sound nuts to you when I tell you what it is, but it was truly a state of emergency for this particular town. In 2017, there was one town in the state of North Carolina on a bright, sunny day with very calm winds that was impacted by a known phenomenon that was coming, and it was known that it was coming. For months, they knew it was going to hit them in one day. It was a town of about 1,700 people called Andrews, North Carolina, in the far western part of the state. And they were dead center, the only town, the only municipality in the state of North Carolina dead center on the path of the eclipse. We had airplane flights at the airport on 50-second intervals, private planes coming in. We had about 20,000 people. We had motorhomes, vendors. We had everything you can imagine from Barnum and Bailey Circus land in that town, and there was nothing that we could really get ahead of because they were just coming. They were landing at that airport, or they were driving into that area. And I said, you know what? Before this thing gets here, let's just decide that we're going to, for 48 hours, mayor, members of the council, there's a draft state of emergency for this period. There's no way we're going to try to even get our hands on what's going to happen in this town for that 48 hours. Now, did it let lawlessness and recklessness prevail? No. It didn't suddenly allow shooting downtown or, up in the air and riding horses and going crazy and drinking everywhere. It was just about mostly the planning things in the planning ordinance, parking-related things, motorhomes in front yards and backyards and side yards, and anywhere you could squeeze them in. And so that's just an example of how that tool in the toolbox has actually even been used for the most absurd type of an emergency you can think of, and that's just simply a swarm of bees, or people, rather, converging on a community that was not able to really prepare itself for that. There's nothing they could do about it. They couldn't cancel it. They couldn't do anything about it. So I wanted you to see that. So that's Article 1. Article 1 is that thing that is all about ordaining and setting the groundwork for how an ordinance will survive over time. Article 2 is going to be coming at you at a much later date. That's why you don't see it in there now, but I want to tell you just a little bit about what it is. It's general stuff that might interest somebody who already has a house and kids and family and fence and whatever else, and they decide they want something more. They want a swimming pool, they wanted this, they wanted that. So that's why Article 2 is right up there at the front. It's going to have that stuff. Article 3 is definitions, abbreviations, and symbols. It's mostly definitions. But believe it or not, abbreviations and symbols have been challenged in cases before over what's it mean? What does this mean? What does this AC dot mean? Is it air conditioning or is it acreage? So it spells it out. But for the most part, it's phrases being defined. Only occasionally are there just individual words being defined, and it's really just in the context of this ordinance where something needs to be spelled out a little clearer, that Webster's wouldn't be able to cover it. Webster's isn't going to tell you that abandoned means X number of days, 60 days. Webster's doesn't quite go to that level. That's why that term or that word is defined in here. The rest of it is predominantly phrases, accessory use, adult establishments, that sort of thing. So I'll leave that entirely to your reading pleasure. And when you see these things and you say, I don't even want that in my ordinance, I always get that about the adult establishments. I'm sorry. That is a protected industry in the state of North Carolina by the laws of this state. We have to have provisions in our ordinance. Some people might say, just take that out. We're just not going to, no, that's not an option. Not an option. I'm sorry. I'm not advocating, I'm not condemning, I'm just saying it's not an option. And there are a number of those that you'll discover along the way. Article 4. This is the story of you, Planning Board and Board of Adjustment. I'm trying to remember our conversation, Hunter. Do you have a separate Board of Adjustment, or is this a dual-purpose board?
Currently, it's separate, but I think the intent is to actually make it a dual board just because of our struggles in finding.
Well, the way I write this and the way I recommend it is that you keep them as separate boards and appoint the lucky members to both. And don't double up the meetings. You don't need both meetings, okay? My recommendation is you might have 10 planning board members or 10 planning board meetings in the course of a year and 2 Board of Adjustment meetings in the course of a year. Or you can stack a Board of Adjustment meeting during a recess and a planning board meeting. So the planning board might start at 6 and then recess at 6:30 to conduct a Board of Adjustment function and then reconvene the planning board meeting at the conclusion, so that they're same people, but you're wearing 2 hats. It's a lot easier and it's a lot more defensible in the arguments that may result because there's such different roles. One's advisory and one is quasi-judicial or court-like. So this is written not with respect to who these members are, but my recommendation is that you tap that same pool because they're such a closely related functions, but different functions. So when you read through this, I've got it set up right now. How many members on your board do you have now? 7? I've got it set up for 7. 7 actually is the best number. Because guess what? If they also serve as the Board of Adjustment, you really need 5. And at least 2 alternates. Works out pretty good. Some people might say, well, why don't we just make them all Board of Adjustment members too? You can't do that. A lot of towns have done it, can't do that. Because the statute has a provision on variances that requires a 4/5 majority. And if you had a 7-member Board of Adjustment, what is 4/5? You can't land on it. So the next thing that happens, if you've got 6 members, it's 83%. So you're moving from 80% required to an 83%. So you're raising the degree of or burden on the applicant. If you go to 7 members, it even gets higher. It's around 87%. You can't get to a 4/5 again till you get to a 10-member Board of Adjustment. So I recommend 5-member Board of Adjustment, 2 alternates. Now, do the alternates get the night off? Not on your life. They're critically important to attending and even being seated. Okay, and you may rotate, you may do all kinds of things to decide who's going to be our alternates for this next case or something like that, because ultimately, somebody's going to say, well, yeah, that's one of my employees that's wanting to buy that or build that or do that, or a family member. And you'll see in here, it talks about conflict of interest, and for planning boards, it talks about it on page 2. For boards of adjustment, it talks about it on page 4. And that's close familial and business-type relationships are taboo, and it's spelled out in the state statutes now. It was one of those things that was more wrapped around case law than it was written law. Now it's all written out. And so it's very important that you have those alternates engaged. Now, why not just say to that person, well, you stay home then, and we'll get an alternate to come? Well, not quite so simple, because typically, at the beginning of a Board of Adjustment or quasi-judicial case, the chair will request any declarations of conflict of interest. Does anybody have a conflict of interest before we begin? And then they can say, well, yeah, I'm related or whatever. But more importantly, a lot of Board of Adjustment cases get continued. They'll hear the evidence, and then they'll recess and reconvene at their next meeting or whatever to make their decision, or for there to be more information or whatever. Well, what happens at the grocery store? Hi, Madam Chair. I hope y'all are going to look after us on that request next week. Good to see you. Take care. You just got ixnayed on aisle 12. And so the next time when you reconvene and the chair calls for any conflicts, you've got to declare that. That's called an ex parte communication. An ex parte communication. And the best thing you can do on that is not debate what the conversation was about. Just declare it and take a seat out here. And another alternate pop in. So you see now why the alternates are so critically important, to hear everything, to be at the meeting from the beginning, because they can suddenly be relied upon right in the midst of an important case. So this is about the boards. This is about the boards. Okay? Pretty straightforward, pretty short and sweet. Leave that to your reading pleasure. Now, as we go along, I check the first box on my reading guide that says I've at least introduced that article to you, so I can kind of keep track. That's what I do with my little reading guide. Everybody's got their little reading guide, right? It's got the two little boxes out there. First one's for intro, second one's for review. Article 5. Told you this was not going to be too bad tonight, right? Article 5, amendments to development ordinance and zoning map. Your most common amendment is going to be a zoning map amendment, better known in the back alleys as a rezoning. A rezoning. It's still an amendment to the law of the land. And believe me, your development ordinance technically, literally is the law of the land in your community. This has become the centerpiece of decision-making under 160D in my eyes. Not necessarily all planners, I don't think, even look at it that way, but I certainly do. And here's why. And I gave you a brief statement about this early on, and I'm going to reiterate this again. And I brought the statute. When the statutes were updated, there were two main goals. One was to take all the case law, which is, for those of you that may not know, case law is the way a court ruled given a certain set of circumstances and facts on a matter related to a zoning type of ordinance. And that ruling may have added some flavor or clarification about how to interpret a particular topic. Even though it wasn't in the written law, that determination might influence how we have to administer the written law. The second aspect was that the planning legislation in North Carolina was originally enacted in 1959, and the version that was being replaced back a couple years ago was originally enacted in 1959, and it had been modified for 50 years or 60 years almost, with an update here and an update there. And based on the original organization of the planning legislation, they would try to find a convenient place to stick these amendments. Well, let's put it over here, kind of close to this, or maybe we'll put it down there. And it became a very convoluted over that half century or so that it was in place. So the State Bar Association had a little committee of 3 that started looking at bringing the case law in, so it's not something you have to go look up in cases or go find hidden under a rock. It's stated in the written law, and let's reorganize things to clean up that disconnected feeling that it had. Along the way, it became therefore clear that some of the cases ended up even conflicting with each other a little bit, and some best practices had to be sort of filtered into it. So what this case and that case, and they don't quite agree, so what do we say here? What do we say in the law? And so there are lots of pieces in there now that, to put it succinctly, imply some things that they don't quite come out and say as strongly as they could individually. So borrowing the saying, the whole is greater than the sum of the parts. Anybody ever heard that one before? It applies in here. You got these little pieces and these little pieces and those little pieces, but taken together, they say something more powerful. And I figured that out when I was trying to update my standard provisions. A lot of this stuff is boilerplate that you're looking at right now in the boring stuff. A variance is a variance is a variance. A rezoning is a rezoning is a rezoning. The facts change, but the processes are essentially the same. And I was struggling with cleaning that up when it dawned on me that complex problems don't always have to have complex solutions, that the answer was right under my stinking nose. That nowadays, it's just not sound practice to follow some of the practices that we used to in the past. Now, what do I mean by that? In the past, you might look at my subdivision. Here's Rick with his subdivision he wants to show everybody that he wants to do. It's family land. We just want to cut 7 lots. You know, it's a 10-acre site. It's going to be great. Housing is going to be fantastic. So-and-so's my builder. Blah, 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 right? And you're looking at it and going, well, you know, I'm a little bit concerned about that number of lots in there, or I'm a little bit worried about where that entrance road is. I don't know if I can support this or not. But it met all the stuff in your current ordinance. Well, guess what? If it meets your ordinance, you can't. The boards, nor the staff, nor the council can sit there and say, no. Okay? Well, they can, but you're going to lose if you get challenged on it. That subjectivity was those little pieces that kept getting pulled out. We'll call it an administrative determination. When Hunter reviews a plat and determines whether it complies or not, or a site plan, or whatever it is, on a permit application or a development request application, that's called an administrative determination in the statute. If a planning board, if the council says it wants the planning board to do that function because we want them to make the decision about big projects like a subdivision. We don't trust Hunter to do a whole subdivision by itself. We're going to get the planning board to do that. What's the difference? Still an administrative determination. You're just passing his hat around real quick, but you're wearing his hat. If the council says, well, we're the council, we're going to make that final decision. Staff can review it, planning board can make a recommendation, but we're going to, by golly, decide whether they can do that subdivision or not. Guess what? Same thing. It's an administrative determination. If it meets the standards of the ordinance, they have the right to do it, and that administrative determination is appealable to the courts. And if it involves subdivisions, it can bypass the Board of Adjustment and go directly to Superior Court. They've got a passing lane now. They didn't have that. There's lots of little things in there that changed. And if it's a subjective decision, will the town win? uh-uh. 100% guaranteed, no. Now, so that's little pieces. I've been stacking little pieces together, right? Another little piece that got added in here was if someone appeals an administrative decision in the past, and went to Superior Court, typically the judges, because they're bench trials, meaning there's no jury, it's just before a judge, and it's usually a due process, Your Honor, here's all the evidence, and you go through the witnesses, all the experts and everything to prove that you met all the standards, and this was terrible that the town rejected it and everything else, whether the planning board did it, whether the council did it, whether staff did it. At the end of the day, the town would probably spend about 60 to 70 grand to go through a Superior Court bench trial to defend one of those type of cases, and the developer would probably spend anywhere from about 100 to 250 or whatever, because I shouldn't say spend, they would claim that because they would put in their cost of their experts and all these direct costs, and then they would also put in their soft costs. Well, we lost the contract. Well, we lost, we had this much carry cost on our deposit money that we'd put in. They're going to claim a lot of stuff. And now, and I'm a reenactment actor on the side, not really, but I'm going to pretend to be. When I say, well, Your Honor, I did my best for this client, and I really appreciate your seeing it the way you saw it and everything, but I just want to make one last request that we spent this much, and here's all these things that it cost us to do this. We lost a year. We lost our project, we lost our contract on the property, we spent all this money. We want you to, be considerate of our expenses, and a lot of times the judges wouldn't want to hear anymore, so they would just say, everybody go and pay your own attorneys. Change that. Now, it's not losing party pays. If the developer loses and the town wins, town pays its attorney fees and they pay theirs. But if the town loses and the developer wins, town pays all costs, automatic. So, all these little parts, the liability exposure, oh, and by the way, we haven't seen attorneys yet advertising on TV. There's money there for on-the-job injuries, workers' comp claims, auto accidents, you name the list. There's money out there, or we wouldn't see those TV commercials. I'm waiting on the day that I see my first commercial in North Carolina that says, have you had your zoning rejected today? Call 1-800-LETS-GO-GET-'EM law. Because the money's there now. And I know 2 law firms that now have little arms in their practices that are looking. They're literally looking. And I was involved in a case recently where we actually won, and the judge says, it's the first one I've seen that's been won. The 7 I've seen before this were not won by the town. So it's out there. It's happening now. So with that liability, that financial exposure, things of that nature, all swirling around in these little pieces, along with the fact that subjective decisions, and whether they're made by a board, whether they're made by the governing board, whether they're made by the staff, are all appealable. That was when my aha moment occurred. I said, you know what? I can't write around this complex environment, but complex problems don't have to have a complex solution. What's the one thing that would remove that concern altogether? The legislative decision. Councilman, that's you guys. The legislative decision. No subjectivity about a site plan, but the legislative decision is a change in law. That's a legislative thing. The zoning map is a page in the law of the land. A change on the zoning map is a legislative decision. In fact, North Carolina law has required now for about 20 years that those decisions be justified with a statement of consistency and reasonableness, in fact, correct? But what's required of a no vote? No vote means you're not changing the current law of the land. So, me and my not the smartest tool in the shed approach decided, let's shift the burden to the zoning map. So that if you don't want 3 units an acre or 2 units an acre or commercial in that area, don't zone it for that until it's time. I'm writing an ordinance that'll be adopted this month in June, next week, day after tomorrow in June, towards the end of June, where they had a huge extraterritorial jurisdiction and they zoned everything that was not commercial or downtown or whatever, RL, residential low density, and that had a, this is not gonna make any sense, but that had a 4 unit per acre allowable density by right across the board in every inch of their jurisdiction that wasn't commercial or industrial or downtown. And that was huge. You could pick Marvin up and drop it in there half a dozen times. That's how big that area is. And they were wondering why they were getting all this crazy stuff going on, right? So when they adopt their new ordinance about 3 weeks from now, their new zoning map, you'll see all of the undeveloped areas pulled back to very low density, 2.5 acre minimum lot size, basically open space, agricultural type area. The parts inside the town limits will have more specifics to them because they can do that. In the ETJ, it's a little different story because of the way the statutes are written on bona fide farms, but at least you can prevent, true farming or, like a big chicken houses or something like that. So it got a handle on it. So every project now that would come forward in town, with the exception of a couple of targeted areas where they know they want to get something moving, would require a rezoning.
Rick, can I jump in here real quick? Because
Yeah.
I want to, so 2 things for planning board purposes. So 1, this is all important because the question always gets asked to me, if it's the minor subdivision plats, like why is this coming to us, or what authority does planning board have to, in this? And I always tell you, it's like, if it's in the ordinance and complies, that's how our current process reads, and that's why it comes to you guys. The second part on the legislative decisions, just want to reiterate, like, this is how we have the Heritage District set up, as a legislative decision. All because we have an ordinance with regulations and stuff for that district does not mean that that applies to those properties until they are properly rezoned. So that's the reason we kind of went that route, because that was the protection that we could put in place for any crazy idea out there, is that it has to go through this process. And that leaves it up to, okay, yes, we have these ordinances in place, but they don't apply to you until you were properly rezoned through this legislative decision. The biggest issue with our ordinance right now, or our current ordinance, and you've heard me stress this, is that 90%, if not more, of Marvin is all zoned the same district. And if it's permitted by right and those regulations are there, doesn't matter even if it's going to planning board or council for approval. If they comply, they comply. And that's what we're trying to. So like, the process is one in itself, but when we get into the regulation side, that's where, even if we're gonna keep it administrative, that's where your guys' input and even council is gonna be very important, because then we're setting what those parameters are. Like, that's your chance to then have that control and have that say compared to how it's kind of been done in the past. Does that make sense to everybody?
And we'll be talking a little bit about how roles change, but still engage planning boards and things just a little bit differently now. And I think you will find it to be more fun, actually. That's what we have experienced so far, so that you are less controversy board and more visionary board, but you get to provide input along the way on all those projects that meet a certain threshold, not just building one house, but doing a subdivision or doing a project of some sort would still go to you for your input, so you wouldn't be voting them up or down. See where we're trying to put that safety net, but keeping you involved, so you would become part of the technical review process of a subdivision to provide input on it, because you may see something from living in that area that the stormwater engineer that's viewing the plans online doesn't pick up on, or a traffic person doesn't pick up on, because you've driven through there at night on a rainy night in the wintertime or whatever. So we're not taking you out of the mix, nor are we taking the council out of the mix, We're just changing it around, and we're going to have some tools in the toolbox, and that's where we're going on the second part of this article. So let me kind of run through 5 real quick. There's some basics in here about initiating amendments and things of that nature, which could be text or rezonings, and you'll see on page 2 in the amendment process, I've got yellow highlighting on a neighborhood meeting. The neighborhood meeting, are you requiring those now?
Yeah, for any subdivision, obviously even by right, subdivision and conditional rezoning has to have it's, in our current ordinance, it's deemed a public involvement meeting.
What I'm putting in here is a neighborhood meeting for any rezoning. Any rezoning. Now, the purpose of a neighborhood meeting is not a meeting by the town. Planning board will have it on the agenda for them to make study and recommendation on a rezoning. And of course, the governing board, the council, will have a legislative public hearing at its meeting before it can enact an ordinance to amend or to rezone property. The neighborhood meeting in this context is actually the developer's meeting. They host it. Now, they might do it here or in some other convenient location, but it would necessitate the staff member being present during that meeting for a couple reasons. One, to make sure that the developer is not answering technical questions about the ordinance or questions about the procedure. So if I'm a homeowner and I'm concerned about this thing going in on the property across the road, and I ask the developer, hey, well, what's the next step, or, you know, something like that, that's really a question that Hunter should answer about the next step, the actual process. You know, let them talk about how lovely the homes are going to be and how many bathrooms and bedrooms and solar panels and whatever else that they're going to be offering in their new package. Let them do that with the person, but it gives them an opportunity to meet directly one-on-one with the neighborhood, and usually in about an hour on a typical project, at least the emotion has started to fade. And they've gotten to where they may not agree, they may not like, they might not, but that emotion, that fear-driven emotion has sometimes faded. And my whole idea in recommending this, that is optional under the statute, okay? You don't have to do it, but I recommend it because you don't really want it to get to the legislative public hearing at the council, village council level, and that emotion walks in the room. Then you're going to be, the council's going to be sitting up here watching a battle between somebody at the podium as a developer and everybody in the room that just wants to talk from where they're seated. I've been through this a few thousand, million, trillion times. And so that's why I recommend it as something to enable the governing board to actually host a public legislative hearing where they hear from the citizens. They hear your recommendation on the rezoning. They hear the citizens, not in my backyard, not right now, not today, not ever, opinions. And then they are the ones that signed up to make that decision at the end of the day when they ran for office. So that's the reasoning behind it.
I have a question for you.
Sure.
So how far does that trickle down? What happens if a homeowner goes to an HOA and says, you know what, I want to put 1,500 square feet on my property because my in-laws are going to move in, I have to take care of them?
No, this is under,
that doesn't trickle down.
this one is under rezonings. Anytime there's a rezoning, any and all rezonings, it could be a little bitty corner lot, it could be a big piece of property. This is on rezoning. Now, when we get into permit stuff, Article 7, we will revisit. See, this is not permit stuff right here. This is the rezoning. Remember the silos. Rezonings are over here. The permit stuff will come later. As Hunter was just pointing out, you got to make the decision about the rezoning first before you can advance the ball in any direction. You can't start submitting plans for review. I won't accept them in towns where I'm the administrator. I won't accept them. I just tell you, you know, that property's not zoned for that. I'm not even accepting your plan. And I'll meet with you as a pre-application meeting and tell you whether I think, you know, you're going in a good direction that works with our ordinance, but we're not going to review them and give you any indication as to whether they're approvable or not until the council takes the legislative action to actually designate that area eligible for it. You follow me? Okay. I know this is, I warned y'all this was gonna be boring.
These do sound like, the neighborhood meetings do sound like our public involvement meetings.
They do, because our current public involvement is like, for example, for the conditional zoning, it's still set up the exact same, like as in kind of the intent behind it. It's ran by the developer. It's the intent behind it is for the public to come and learn about the project, tell them how much they hate it, love it, whatever. And staff is here to then provide input on a technical approach. I mean, we had this happen just with the ZEPSA one. We sent the notices out last week. I've had a guy call me 7 times between Sunday night, don't know why I would think I was in the office on Sunday night, and now. And the notice specifically even stated that staff has not reviewed the site plan, any of this, that this is the initial step in the rezoning process to have the public come and learn about the project, the process and everything, and their opportunities moving forward, on what their public like involvement type process is moving forward, i.e., you know, planning board meetings, council meetings, the public hearing itself, all of that. So it is set up very similar.
But it's required.
Isn't the neighborhood meeting the same as a public involvement meeting, basically? Yeah.
It is.
Except what he's saying is that he's suggesting that the neighborhood meetings be optional. Our public hearing meetings are required, correct?
Per the ordinance, yes,
Yeah.
our current ordinance.
I'm not offering it as optional.
Yeah.
I'm
Oh, I
saying
thought you
you
just
have
said-
the option, you have the option of deleting the yellow paragraph. It's not required by state law that you do it. It's authorized, meaning you have the option to require it or not require it. I recommend that you require it, and I recommend that you require it on every rezoning. That's how I recommend it.
Okay,
That's,
thanks for the
so that, yeah, it's not optional that you do it on this case and not that case.
So you're authorizing or suggesting public involvement and neighborhood meetings?
No,
No, it's the
sir, it'd be
It's the
one
same
meeting.
thing?
Same thing.
Same thing?
Right. Right, but it would be on all rezonings, and then we're gonna have the same kind of thing come up a little later. Now, I also use the terminology that's found in the statutes. The neighborhood meeting is what it's called in the statutes. I don't switch the terminology around in case you gotta defend it.
Hey,
I'd hate for somebody to say this involvement meeting's not authorized by the statutes when a neighborhood meeting is, and it's just a matter of semantics. On the next page, page 3, and I'll leave all that content of a valid authorization for applications for your reading pleasure and the review by the planning board to your reading pleasure, but I want to call your attention to the yellow provision on whether, because this is ultimately going to be something that's enacted by the council. So that means that the council is going to set the policy. But I want you to look at what kind of leeway do you want to have, because this is a pressure point. There's always a contentious aspect around planning boards delaying rezonings by continuing a meeting or something like that. And so a lot of councils will say, can we limit their authority? The yellow language is how you limit their ability to delay that. You follow me? So that you can't, now the number, there's nothing magic about 8 days. Y'all pick a number. 8 years, you know, y'all pick a number, but to me, that's, Councilman, that is where you set in play a kind of a deadline. Like, once they get it, they can, and after they've had their meeting, can they continue? And the reason I use 8 days is in case you were to continue from Tuesday night to next Tuesday to discuss it, or do you want to have a month, or do you want to have 8 months, or do you want to have 8 years? You know, 2 years, 10 years. I want you to look at that phrase and know that you have tons of flexibility. 8 is just a placeholder stuck in there. To me, it would be a minimum of 8 days, so you can at least get to the following week. I wouldn't go any shorter than that, because Councilman, to me, planning boards need that ability sometimes to step away, go by and visit a site, something like that, come back together, and then make their recommendation. So that would, to me, be a minimum number of days, if you're going to do that.
Our current ordinance says 60 days from the time it's been first introduced, which basically means if it's introduced, like if it was introduced at Tuesday's meeting, for example, or this month's regular meeting back on what, May 16th? Then technically you guys would have until July 16th to make a decision. Most ordinances that I've seen, typically it's 30 to 60. It's kind of the intent of having potentially an additional regular scheduled meeting, if not two.
Yeah, 8's a minimum. Anything longer than that, it's up to you, and y'all just let me know anytime. It'll stay yellow until we do something. We either leave it, or we change it, or whatever we do. And this is a very good place for me to mention to you how the review will work. When we talk about this next month, somebody might say, well, you know, we've been thinking about that. I'd like to change that to 60 days to match what we've been doing all along. There's no reason not to. Sure, no problem. Then when I replace your pages, I will send a file into the staff of the whole document corrected, but I will ask them to redistribute page 3 and 4, and it will have a watermark for that meeting in the future where you get that one, so you'll be able to look at it and go, yes, I've got the updated version. I know which one it is, you know, because the watermarks will track, that's sort of like the addition, if you will. So with that said, we can move right along. The rest of it is reading for your pleasure. And, sure. You typically are continuing the agenda item, yeah. Like you'll just say, well, we're not gonna vote on that tonight. I don't, you know, if we don't have a motion, we'll just wait. It'll appear, it's called tabling. When you table, it goes to the next regular meeting. You can't say, I'm gonna table it for 2 months. A lot of people will do that. They'll say, well, we want to table this till our September meeting. Tabling means to your next regular meeting.
One quick point. If you're going to ask questions, please make sure your microphone's on. That way it's in the record. Sorry.
Well, the way this is written is you're not going to make it to your next regular meeting. That's why it says continue the meeting for 8 days. Like if you just say you're going to continue till next Tuesday.
You're going to recess the meeting till next week.
If we go to 60 days, we'll change it to where you can do it, but you might decide you just need a week. So you can continue the meeting, or you can continue the item if you're going out 30 or 60. Or 30, I'd say 32. You're going to need at least 32 to cover potential conflicts with different calendar months.
And that's our problem with our current ordinance, is that the question is, okay, if it's 60 days, and the intent of that is, once again, 2 meetings, but that doesn't always add up. And I kind of disclose that, make sure you guys are aware of that. We do try to structure it where it works out that way, but my recommendation right now, and once again, we can kind of discuss this later, would at least be maybe the meeting gets introduced and then 2 concurrent regular scheduled meetings, and however that, we need to work that out in the time frame, great, but that's just my recommendation.
Yeah, I would use 64 days instead of 60 days if you're going to try to do 2 real months, that kind of thing. There's a funny business in the calendar. I don't know why we don't have 13 28-day months, because it would work out perfectly if we did. So y'all let me know your appetite on that, because I'll still write it in the language that gives you the flexibility to not just bump it all the way to a regular meeting, but to continue the meeting. If you feel that there's a sense of urgency to get it behind you, but you need a little bit of time, you don't need a month, or do you just want to say a month, or to the next regular meeting, or to 64 days, or whatever the case is. I'll leave that one up. I've made a note in my calendar, and you'll start seeing lots of these little orange flags pop up in my notebook, because anytime I make a note, I flag it. All right. And then of course, it gets into the conflict of interest on planning boards too, by the way. You know, that's sort of restated again. It's in the planning board part, but it's also in the procedures on rezonings part for a reason. So it gets noticed, so it gets seen, so it doesn't, well, you know, I know I talk about silos, but there are times when you might want to put a little bit of your money in a couple different accounts, right? And that's the way I see this. It talks about the village clerk or authorized designee preparing the notices. Austin, that's not intended to put everything on you, on rezoning notices and everything, but clerk world is a critically important aspect of tracking changes to the law, right?
I'm very
Ordinances.
good at drafting additional help, so we're good.
Okay, all right. On page 7, there's another item I want to call your attention to, and it's the, what some people call the cooling off period. Let's suppose a rezoning has been rejected by the council on a particular piece of property, but the property's still on the market. Very common scenario. Somebody else has been waiting in the wings and pounces on that opportunity because they've got a different idea. Or maybe it's the same person and they've, want to try it again because they feel like they've addressed the concerns. Or there's been an election in between, or any number of reasons that they want to bring back a new application on that property. I've seen some jurisdictions try to say that you can't apply for the same thing again on the same property once it's been done. That is not legit. You cannot do that, okay? You can put in a cooling off period, but you can't tell somebody that they don't have the right to apply for the same thing they applied for last time. Yes, they do have that right. I could apply every month for the rest of my life to change your leash law to allow me to have a 50-foot leash, and y'all could keep rejecting it, and I could keep bringing it back. That's my right, okay? Y'all might not like it, you might not listen to me, but it is a right that I would have. So these ordinances that say, well, if we rejected that, you can't bring that back. Again, yes, you can. That's right. So, cooling off periods, however, are another way of at least getting some of the emotion out of the room that might follow a rezoning process, okay? Because usually when there's a rejection, there's also been some emotion in the picture. 4 months, 12 months, what do you have today, Hunter?
I don't know. I don't even know if we have this
Okay.
in our language.
I recommend having something, just so that things cool off. Now, if you'll notice, right below it in paragraph B, as in boy or basket or whatever, ball, there's a waiver provision that the council can exercise because they may deem there to be a sense of urgency on something. So there is a process around that, but it is a conscious process. It's not just, hey, Hunter, come on, buddy, let us get that application in, you're killing me. That's the most famous saying that a developer has for us planners is, you're killing me. So I try to minimize those and head those off. So anyway, there's that piece, and that will stay yellow until you give me some idea. Page 9.
Rick, can I ask a question about that real quick?
Yeah.
And I've seen some ordinances do this. I know it's not the best approach, but whatever the time that we set, is there any type of language you would recommend? Like I said, this could go one or two ways, that it could be waived by village council, or like, let's say we say that it's a 6-month cooling off period. Let's say we have elections. Is there any type of language that you've seen that allows for council potentially to reconsider something and/or?
That's what I was describing as the B there, unless I'm misunderstanding your question.
Well, I'm saying, no, I know what the time, like, let's say we set the time frame.
No, I'm talking about below it, B, item B right below it, the waiver period.
Oh, sorry, I was chatting with him, my apologies.
There you go, Austin, your fault. You're gonna note that in the minutes?
Duly noted.
Okay.
Yeah, I think that's what you were talking about, right, Hunter? Yeah,
Yes.
there is a provision in there so that the council can, if there's a sense of urgency for a justifiable reason, they can make that finding and waive that period, okay? But that goes to council, because it is a change in the law. Conditional zoning on page 9, and the rest of this article, about five pages left there, are about conditional zoning. And I did in yellow what I want to bring up to you. I really probably should have, but it's on the first page. And it's near the bottom, it's under general requirements, that 5.4-3, it's C as in cat. Some developers and some towns have viewed conditional zoning as an opportunity for an applicant to come to you and beg for leniency. Let's suppose in this R1, there's a 20-foot setback requirement or something like that on the back or the side or whatever. And they want to build a bigger pool and put a building in a, pool house, a clubhouse, a, bathhouse, whatever, spa and sauna and everything else, accessory dwelling, whatever they can pile out there with it. And so they come to you and they want to do a conditional rezoning for this neighborhood that's going to have all these amenities, and they want that conditional zoning to allow for a 10-foot. And that may not be the best example, but it's wrong. Conditional zoning is not about waiving standards or reducing standards. And I don't know how you've used it in the past, but that's not how it works, okay? Conditional zoning is about gaining a privilege. I want to have some townhomes. I want some townhomes, so I'm going to apply for a mixed-use district rezoning that also allows apartments. Oh my God. So I come to you with an application that says, I would like to rezone this property so that we can do these 6 nice townhomes here at the front, because it just fits better with your downtown plan and everything. But then the rest of it's going to be beautiful big homes and all this other stuff. So I'm going to apply for the mixed-use district in a conditional zoning. So we'll call it mixed-use CZ. And I'm going to strike apartments from the uses permitted by right in my rezoning, but I want to keep single-family houses and townhouses. So I've given up a mixed-use privilege, apartments. That's what I'm asking for, is a CZ type of zoning, mixed-use CZ, so I can gain a privilege. I still have to meet every standard in the book. That's what a conditional zoning is. And that paragraph C is in cat, all standards and requirements of the corresponding primary general use district shall be met, except to the extent that the conditions imposed by the conditional zoning are more restrictive. So they don't use conditional zoning to get a break on the physical dimensional stuff. Now, maybe that other district has lesser than the district that it is now. Maybe this mixed use doesn't require as big a setback as this single-family residential does. But whatever it is in that primary district, the corresponding primary district, that mixed-use 1 or whatever it is, I have to meet all of those standards. I can't say, well, it requires 6, I want only 5. Can you cut me a break on the 5? You follow me? So that's the way I write my conditional zoning. So it's really about they pick up a use, but all the district standards remain intact. So that's how you use conditional zoning in this
Is it
particular
kind of like an
general case.
exception?
Pardon me?
Would you say it's kind of like an exception?
Exceptions are illegal in North Carolina now. That was one of the things 160D just took away. They just pulled the plug, threw it away. They also threw away conditional use permits, and they also threw away conditional use districts. So they threw out 3 of the 5 tools that typically have some type of conditional component to it. They threw out 3 of those 5. They kept conditional zoning, which is the way I just described it. You get the corresponding primary district and you cull it a little bit, but you meet everything else. Or you have a special use permit, which is really for the scary stuff, not normal stuff. House is not scary. Landfill, cell tower, asphalt plant, quarry, recapping facility, chemical plant. Scary stuff is what you do with your special uses. And we'll get into that much more in a few meetings, but those things that have to have a lot of conditions, and in fact, your draft ordinance will assume a lot about those, because we've been around the block on those a million times. I know every single concern there is about a quarry, and I've heard it in 400 different varieties, and there's usually seldom a difference between them that you could shake a stick at. So we can spell out standards pretty clearly. So you make it right up front. They want to bring us something scary, well, we're going to scare the heck out of you with our standards. So you arm yourselves with the right tools in the toolbox. If you don't, then you can fall victim to those attacks, those legal attacks, because you can't sit in the room and tell somebody, well, we're only going to approve this if you'll agree to do that. Oh boy, you're walking right into a hornet's nest. Spell out your standards in the ordinance. There may be an additional standard you need to add because there's a wetland right over here, and you want to make sure that there are at least a little of this or a little of that. Will you agree? And if they say yes, get it in writing on the application. So Hunter pulls the application out right there, gets a pen right there, they add it, they get the applicant standing up here in front of you to sign it right there in the meeting, and it goes in the minutes. That's the law now. They don't say, sure, we'll do that. You write it, they sign it, it goes in the minutes. That's the procedure. So everything is extremely clear now in many, many regards. Okay, follow me? So conditional zoning's still alive, special use permits are still alive, and that's it. So this conditional zoning follows a lot of the same provisions. But I've had to add, and you'll see this on page 10, because conditional zoning can get very, very specific. Maybe there's a site plan, or there's something that you need to deal with in that particular area. And these are yellow because you may look at this and you may say, well, we don't want to do this at all. But the statutes now allow for you to build into a conditional zoning. They allow for you to build into a variance. They allow for you to build into a special use permit. And they allow for you to build into normal rules and regulations, administrative modifications. And so that's why you see that yellow. You may not like the 24 inches or the 10% or something, then that's fine. You may want to change that to 1/4 of an inch or to 10 feet. That's up to you. That's fine. But I wanted you to see it because you have the ability to delegate some administrative authority to your staff. Now, why is that important? And you're going to see this when we get into future articles. If you've got, let's say you've got a 18-foot setback on the side for accessory buildings or whatever in a particular district, and they go out and they set it up. This was a pre-manufactured little, cute little place to put lawnmowers or something that gets delivered and set up. And somehow, maybe it's a neighbor, says, Went over there and I measured it, and it's only 15 and a half feet. It's supposed to be 16 feet. It's 15 and a half feet. Every town's got citizen number one, right? Some of them have more than citizen number one. How much authority does he currently have in your current ordinance? Because 16 is not 15.5. 16 is, and minimum means 16.0 at a minimum, right? The statutes now allow us to say, you know what, let's define some criteria and give them a little leeway, okay? So you'll see numbers pop up in some of my standards like 7.5 and 3.5. Why? 4s and 8s in lumber and construction. Somebody might point brick a certain way, and the next thing you know, somebody, the stoop is not 4 feet, it's 3 feet, 11 inches. You follow me? It sounds like I'm splitting hairs. If you don't have the tools in the toolbox for him to know what hair he can split and which one he can't split, and if he splits one, how much, that's what this is. This is the first example you're going to run into. You'll see it pop up in a couple of others too when we get to permits and what have you. So that's what that's about. And all of this stuff is subject to changing. This is just showing you what it looks like if you've got it. Council may say, we don't trust Hunter at all. Take all that out of there. And they may say, Hunter, you got this. We're going to give you this much. And I usually recommend a dimensional, like inches and percent, and the lesser of or greater of or whichever way of that you want to feel comfortable about that in typical scenarios that you have, which for you are largely going to be accessory buildings, primary structures, things like that in most of a town that's largely residential, okay? Swimming pools, whatever the case may be. So I want you to see that and see what it looks like, okay? The next article, more boring stuff, a lot shorter and sweeter, 6 pages, not too bad. Variances, I mentioned a little while ago when we talked about boards of adjustment that variances sometimes can get kind of nasty, and they're unique. Madam Chair, I'm trying to get this done by 7:30. The variances are really defined in our statutes very clearly. We don't have hardly any leeway in here, okay? We really don't have much leeway, but this will tell you all about a variance and what it takes to get one. If there are conditions, on page 3, if there are conditions that need to be assigned, they must be related to the variance. I didn't highlight that in yellow because we're not going to change it, but it's something I want to point out. If somebody comes in and says, hey, I want to do a swimming pool and I'm having trouble with my topography and I think I can justify and show you evidence as to why a 1-foot variance is needed, you can't come back at them about the doghouse or the fence or something that's, well, we noticed if you do the pool, if we give you the variance here on this, will you bring the fence over closer, away from the property line more? You follow me? You can't be getting into conditions that are off the subject of the variance to begin with. That's something that came out of case law that ended up in written law. Just another example of how much was unsaid in the old statutes that was said by the courts that's now in the law. The standards for review are still the same. A lot of that's going to sound extremely familiar to you, but there are some nuances in there that have cleaned that up. Periods of appeals, all that stuff is covered under the appeals, administrative appeals. I disagree with what he said. he rejected my permit for the pool, and I'm gonna appeal, and I'm gonna ask the Board of Adjustment to weigh in as to whether he was interpreting that provision of the ordinance correctly or not when he denied my application. Okay, so this spells out the process for that. That's the other key function, fundamental function of a Board of Adjustment, is the appeals, variance and appeals. Okay. You'll see a third one added when we get to permits, and that's the special use permit. So there'll be 3 functions that I recommend go to the Board of Adjustment hat that, that the volunteers here make.
Can I ask a quick question?
Please.
Does the Board of Adjustment, on an appeal, are they appealing a decision by the village council?
Well, typically, an applicant walks in the door and wants to, you know, build a really, really tall thing for their 9-foot giraffe, and there's a height limit on accessory dwellings of 10 feet, and he denies their permit because they wanted it 11 feet tall. So they're appealing his administrative decision. See, appeals of administrative decisions. He's making an administrative decision. They're appealing his interpretation of some aspect of that. They feel aggrieved that maybe he's being unfair. Sometimes he may be 100% right. Most of the time, if not all the time, he'll be 100% correct. But they still have to have, by law, a pathway to ask for a higher level review of that if they feel that maybe he's got something against them.
Okay,
You
so
know,
it only
I
applies to
saw him shun
administrative
my
decisions.
dog one day, and I just don't, I think it's personal.
So
Right.
it only applies to administrative decisions, not to
Correct.
legislative, which is.
If you make administrative determinations in your deliberations, like you vote on a site plan, guess what? You're doing that. Do you vote on site plans now?
Yeah, to a degree. I mean, certain, I mean, you guys make recommendations to the village council on, for like subdivision sketch plans.
But they don't have final approval on subdivisions. But they have final approval on subdivision sketch plans. Your decisions are administratively appealable under that provision right there. Because you're functioning no different than staff is, and you're supposed to be doing it by what the standards that are adopted say, not by, well, we're the council, you know, we know better than the ordinance does. So I think the underlying message here is that if you believe it, let's put it in the ordinance. If you want it, if you expect it, if you want to demand it, let's put it in the ordinance so it's written, it's clear, it's consistent, it's fair. It's not, well, Hunter's family's always been real good to the town. They donated, 14 acres for the park over here where we're going to have Marvin Day's celebration and all that. So, that subdivision they want to do, I don't see a problem with it. They're such good folks. Yeah, we're just going to approve that for him. But that scoundrel Rick, now that rascal, when he was delivering newspapers, he used to jump his bicycle down there at the corner, and my mother, she had her rose bushes right there beside that mailbox, and every doggone time he went through there in a hurry on Friday afternoon, he would always jump too quick, and he tore her bushes up. I don't think we should approve anything that scoundrel and his family want to do in this town. Those days are over. Over. I get the same rights he does. So if I want to build me a subdivision, and I'm sorry about the rose bushes, I get to do it. So if you want to put a tougher standard, we put it in the ordinance. And we can put all kinds of standards in there. When we get to the character elements, remember that third little grouping in your reading guide? That's where all this, the standards come into play. What do we want those standards to be? Y'all might decide you want to raise the bar. You might want to lower a bar. I don't know yet. But we'll go through that, and I'll be there to show you which ones are out of bounds. There's a few that the legislature has made a little bit out of bounds. But generally speaking, you are in charge of the character of your community. Okay?
Rick, I'm
I keep
trying-
pointing to the council member over
I'm
here.
trying to be clear, so once we approve the ordinance, that's the legislative side.
That's right. The ordinance, the map, those are legislative actions.
Right. And then once he looks at it, he says, or if someone comes in and asks for a permit, he's just looking, he's basically following the body of the law, the ordinance
That's right.
as we said.
That's right.
Okay.
But he may still have to employ what I call the art of interpretation. So this is a very good question, because we can't, if we write in such a way that everything is absolutely cut and dry, something's gonna come up that doesn't fit neatly in those compartments. And so there has to be, Robert Moses, whether you're a Jane Jacobs fan or a Robert Moses fan, that's planning talk. They were two opposing forces in New York. Regardless of which side of that equation, they both were brilliant individuals. But Robert Moses said one time, he said, he created this concept we call the art of bill writing, which was to always make sure that you wrote broad enough to be able to deal with the unexpected. Things that we don't know about yet. Tendencies or trends or patterns and things of that nature that don't fit squarely in a neat little cubby hole. Exactly. You can't touch tiny houses. Forget about it. Forget about it. You know what a tiny house is? It's a house. It's a house. Until you get into stuff that doesn't meet the building code for how many square feet of a habitable thing to keep people from living in a shoebox, it's a house, and it has to be treated the same way. Now, if it's trailer mounted, guess what? Is it a camper or is it a manufactured house? So we use old defined standards to deal with these new trends quite often. Somebody's going to bring it in on a flatbed truck and set it off with a crane, and it's 380 square feet. That's called a modular house. It's no different than a 4,000 square foot that came in on 8 flatbed trucks. It's a modular house. If it's on a chassis and it comes in, it's a manufactured home. No different than any other manufactured home, or what people call mobile homes. If somebody made it on their utility trailer with a bunch of wood and scrap materials, it's no different than a camper trailer. Go get you a little teardrop camper trailer. It's the same thing, okay? And we treat it the same thing. We don't, just because they said tiny house, just because they said Airbnb, Airbnb is not a thing, folks. It's an app. It's a way you book and pay. It's not a thing. It's not a land use. What we have to do on Airbnb is decide, is it an actual bed and breakfast? Well, they rent a room once in a while, but there's not like 5 different rooms for rent. There's not all this going on. So I'm going to say it's no different than Rick letting his sister-in-law stay in the guest room when she comes, next week. And if she gives me $20 to help pay for, I don't know, hamburger meat or something, then so be it, So some Airbnb is not really a land use change, and some Airbnb really is. I got this going on all the time. I got 4 or 5 completely different parties in here, people that don't even know each other staying in different rooms in my big old house. So in that art of interpretation, which is where I'm going, Mr. Williams, that art of interpretation is something that if we try to write that down so jammed up tight, we're always going to find ourselves somewhere in a fine line in between these two buckets. So the art of interpretation still has to have a little bit of leeway. That's where, but they need to have enough guidance in here to where they can make consistent, clear interpretations. And then once you make that, you got to stick to that. Once you decide that the line is over here, that's where you keep that line. Because that's not really appealable. It's if I give my friend from school, Hunter, a break over here, and I don't give Rick over there the same break. That's when it's appealable. Okay? No different than case law at the local level, literally. Okay? So I've kind of taken you down the rabbit hole on a lot of these things, and it's for good reasons. Good reasons, because we're changing, or I'm recommending to you that you change your approach to protect the best interests of this community and how you do what you do. Set clear standards, be clear, and stick to that, and stick to the procedures. And if the standards aren't what you want, we amend it. It's a text amendment. If you look in there, council, planning board, and staff can all initiate text or map amendments. They can initiate that process. You don't have to wait on something now. A rezoning of an individual, you know, you might want to prefer to have them involved, but we can initiate map or text amendments under the statutes in this state. And the ordinance points to that, okay? All right, Madam Chair, members of the board, distinguished council member, and staff, that concludes the introduction of batch number 1.
I feel like we should snap or clap or something, you know. Well done, well done. Thank you, Rick.
Oh, that's not necessary,
All
folks.
right.
Y'all are gonna be y'all are gonna be thinking of other gestures before
Yeah,
we finish
especially when
this
we hit that
project.
definition section, because that is a long section. So, everyone, please do your reading prior to our next meeting with Rick.
Do not adjourn yet, we still have more.
No, I'm not. But the reading has to be done prior to the next meeting, the next recess meeting with Rick, not at our next regularly scheduled planning board meeting.
My question would be, because I believe we had June 20 and 22nd as your regular meeting and then an eligible date in that tentative schedule. What is your anticipation? Do you feel like that I should be here on the 20th, or are we going to do it the same way and do it on the 22nd? Depends on your workload.
Yeah, I would recommend for this June meeting to probably do an additional recess meeting, just because we will have the first review recommendation of the conditional rezoning on top of some of those final Heritage District kind of amendments that we've been discussing. So that will probably take some time, and even if we're not at a point during that June meeting to once again make your guys' recommendations on those, my thought would be, once again, it can be tabled either to the recess at the beginning and/or in July, but then July, we should be kind of back on regular schedule. Like, we shouldn't have in-depth type conversations unless that's a point, but I think for the June meeting, it would be wise to go ahead and consider scheduling a recess meeting.
Which you'll just do at the June meeting. You don't have, we've already got that date in your calendars for now. So just anticipate when we're on, at the June meeting, that we're gonna recess that meeting when we get to the UDO project.
So I will see you on June 22nd then.
Great,
Yes.
thank you.
22nd's the recess date.
All right, y'all carry on with your business. I'm gonna, let me turn this off in case I make any noise.
That's why I just pushed the button there.
And so, yeah, so these binders that have been provided are yours. Take them home, read them, write notes in them, jot down questions. Make sure you do bring them back for that recess meeting, because once again, we will then put the new articles for the next meeting. We'll give you them at that meeting and kind of go through the same process. So these binders are kind of your Bibles for the next couple months, so just make sure you bring them to meetings.
There's a penalty if you don't.
All right, Hunter, you want to move on to the planners update?
Yeah, just I'll mention two things. First one is the public involvement information meeting for the conditional rezoning for the Zepsa property is next Tuesday. This is their second one per the ordinance. This is more scheduled to be a kind of open house. Nothing has really changed from what you guys saw 2 weeks ago. They are working on kind of some minor revisions to their stuff, but it's kind of scheduled to just be open house. Feel free to drop by, see if there's been any changes, also to drop by and maybe, just see what the public's asking, see what they're bringing up. But that will be next Tuesday here at Village Hall, hours 4 to 7, like I said.
If you're planning to come, please let me know, because if I think there's gonna be a quorum, I need to issue a notice for that.
Second thing is the Heritage District updates. Once again, been working on those. My plan was to bring you guys a draft back tonight, been kind of swamped with some other things. So we'll kind of get back on that train during the June meeting. I'm taking all that, our discussion from the last meeting, recommendations, and kind of getting that final draft document. So once again, that will be presented to you guys at the June regular meeting. And then, you guys can make a recommendation to the council, or we can kind of keep working through them. But the one thing I do want to point out is kind of like Rick was saying, it's like with conditional zoning, and I said this last time, it's like we're trying to set that standard in the right area, because we can always go more restrictive. We just can't go less. And that's kind of what that's kind of the intent of what my change is. It's like finding that happy medium, not saying that that's what's going to happen, because once again, it is still a legislative decision through the rezoning process, and then we can always go more restrictive, we just can't go less. So we'll get into more detail on that at the June meeting. And then final thing, if you guys don't know, Marvin Day is Saturday, so come out, have fun.
Most of the board has signed up to volunteer, and you don't know what you're getting yourself into.
I think that was, we were voluntold. That's what that was.
That's the language we speak here. We all get
Yeah.
voluntold.
I don't think we have any action items
No.
besides read your stuff.
Do your homework. Bring your binder back.
All right, then, why don't we, Marcus, why don't we start left? Board comments? We usually go right, so. No, you good?
Good.
All right, thank you, gentlemen.
For your work.
Board gestures? That's what we just needed tonight, board gestures. And, okay, well, do you guys have any comments? All right, well, with that said, could I get a motion to adjourn? And a second? All in favor? All right. Here, I'll gavel it. Boom, boom. Adjourn.